Hey everyone, welcome to the channel. If you're into simple, helpful content, be sure to subscribe. We make videos that are easy to follow and worth your time. Let's get started.
Understanding who owns property after a father's death is a complex but crucial topic. There isn't a single, simple answer, as the outcome depends on several key factors. The most significant factor is whether the father had a valid will in place. A will is a legal document that explicitly states how a person wishes for their assets to be distributed after their death. If a father leaves a will, he names an executor. This executor is responsible for carrying out the instructions outlined in the will. The property would then be distributed to the beneficiaries named in that document, according to the father's wishes. This process usually involves probate court, which validates the will and oversees the estate's administration. However, many people die without a will, which is known as dying intestate. In such cases, state laws dictate how the property will be divided. A spouse might inherit all or a significant portion of the estate, especially if there are no children, or if the children are also the spouse's children. If there are children from a previous relationship, the division can become more intricate. If there is no surviving spouse or children, the property might pass to parents, siblings, or even more distant relatives, following a specific legal hierarchy. The probate process still occurs even without a will. In this scenario, the court appoints an administrator, instead of an executor, to manage the estate. This administrator's duties are similar: identify assets, pay debts, and distribute the remaining property according to state law. Another critical factor is how the property was titled. If the father owned the property solely in his name, it typically must go through probate. However, if the property was held in joint tenancy with a right of survivorship, it automatically passes to the surviving joint owner outside of probate. This is common for married couples. Similarly, property held in tenancy by the entirety, a form of joint ownership exclusive to married couples in some states, also passes automatically to the surviving spouse. Some assets, like bank accounts or life insurance policies, might have designated beneficiaries. These beneficiaries receive the assets directly, bypassing the probate process entirely. Real estate, however, rarely has such direct beneficiary designations unless it's part of a trust. Trusts, especially living trusts, are another way property can be transferred outside of probate. If the property was placed into a trust during the father's lifetime, the trustee would distribute it according to the trust's terms, often much faster, and with less public scrutiny than probate. Debts of the estate also play a crucial role. Before any heirs receive property, the estate's debts, including mortgages, credit card debt, and other liabilities, must be paid. If the estate's assets are insufficient to cover all debts, the heirs might receive less, or in some cases, nothing at all. Taxes, such as estate taxes, might also apply, though the thresholds are quite high in most jurisdictions. Community property states, such as California, Texas, and Arizona, have specific laws regarding property acquired during marriage. In these states, spouses typically own property acquired during the marriage equally, which can significantly impact how it is divided upon death. Given the complexities involved, seeking legal counsel from an estate planning attorney is highly recommended. An attorney can help navigate state-specific laws, clarify property titles, and ensure the process is handled correctly and efficiently. They can also assist with creating a will or trust to avoid future complications. The process can be lengthy and emotionally challenging, so professional guidance is invaluable. Thank you for watching. Please subscribe for more helpful legal information.
Watching, like and subscribe.